Welcome everyone to today's webinar on Maximising Rights in Religious Educational Institutions, International Perspectives. Thank you again for joining today's session, which will be a 1 hour session joined by the ALRC, Walters Kluwer and our international speakers. We'll just give everyone 1 more minute to get logged in before we get started. Thank you again for joining today's session. We're just going to cover a few housekeeping items before I hand you over to our speakers. So if you are experiencing any audio issues, try logging out and coming back into the webinar. All webinar registrants will receive a link to the on-demand webinar recording within 24 hours after today's live session. Please raise your hand if you do require any further assistance. Throughout today's session, if you do have any questions, please use the chat box. So click on the little orange arrow and go to questions to drop in your question and hit send. We'll try to address as many questions as we can during the Q&A at the end. Just a recap of what we're going to cover. We're going to have a welcome from Justice Bromberg, move through to a panel discussion, which will be about 30 minutes. Then we'll have about 15 minutes for Q&A, some reflections, and then we'll wrap up on a little bit about Walters Kluwer and what we do. Now I'd like to hand over to the Honourable Justice Bromberg, the President of the Australian Law Reform Commission, to welcome everyone in.
Thank you very much. Welcome everybody to this webinar jointly hosted by the Australian Law Reform Commission and Walters Kluwer. Can I begin for those of us who are in Australia by acknowledging that we meet on the traditional lands of our First Nations people, and on behalf of all of us, can I extend our respect to those peoples and elders past and present. Can I explain for those who are not clear that this webinar is being held as part of the Australian Law Reform Commission's inquiry into religious education institutions and anti-discrimination law, the final report for which is due to be provided to government by the end of this year. I just want to say something very quickly about the terms of reference of the inquiry. The Australian Law Reform Commission is really charged with advising the government how to implement essentially 3 policies, and I'd like to set them out for you. They are that religious education institutions do not discriminate against a student on the basis of sexual orientation, gender identity, marital or relationship status or pregnancy. Similarly, religious education institutions should not discriminate against a member of staff on the basis of sex, sexual orientation, gender identity, marital or relationship status or pregnancy. And the third policy is that religious education institutions should be able to continue to build a community of faith by giving preference in good faith to persons of the same religion as the education institution in the selection of staff. Now, those policies engage a number of intersecting or overlapping rights, including but not limited to the right to freedom of religion and belief, the right to equality and non-discrimination, children's rights, rights to education, right to privacy and right to work. And the ALRC's task is to essentially advise government as to how those 3 policies can can be implemented in a way which accords with Australia's international obligations. Part of that task, of course, will be to best appreciate how the various rights that I've identified are to be balanced when they come into conflict with each other, as they do. As part have been engaged in numerous consultations, and this webinar is really part of that consultation process. We've received some 428 submissions and over 41,000 survey responses, and consulted with over 120 individuals representing a broad cross-section of stakeholders, including religious bodies, organisations, educational bodies, religious education institutions, equality advocates, professional legal bodies, parents and teachers and religious education institutions, state and territory government, law reform agencies, human rights commissions and children's commissioners. We are privileged indeed to have some esteemed international experts for the panel discussion which is about to commence. That panel discussion will take about 30 minutes, leaving around about 15 minutes for the panel to respond to questions submitted by audience members. Our team will read and consider all questions and comments submitted, even if the panel doesn't have time to respond to them today. They'll all be taken into account. We'll end with the Commissioner for this inquiry, Justice Stephen Rothman, who will offer some reflections on the discussion before Walters Kluwer tell us a little about their services and close the webinar. Can I introduce our three esteemed international experts on our panel? First, we have as our moderator Professor Caroline Evans. Professor Evans is Vice Chancellor and President of Griffith University. She's an internationally recognised expert in religious freedom. Professor Evans has spoken on religious freedom and human rights topics in the US, the UK, Russia, China, Greece, Vietnam, India, Hong Kong, Switzerland, Malaysia, Nepal and Australia, and has given evidence to major inquiries in Australia. We're also privileged to have Professor Lucy Vickers from the UK with us. She's Professor of Law at Oxford Brookes University. Her main area of research is the protection of human rights and equality within the workplace, especially religious discrimination in the workplace. Professor Vickers has published a number of books and articles on related topics and is a member of the European Equality Law Network. Lastly, we are indeed privileged to have with us Professor Heiner Bielefeld. He is a Professor of Human Rights and Human Rights Policy at the University of Erlangen-Nuremberg. His research explores interdisciplinary facets of human rights theory and practice, with a particular focus on freedom of religion or belief. Between 2010 and 2016, Professor Bielefeld served as the United Nations Special Rapporteur on freedom of religion or belief. I hope, like you, we will now have the benefit of an interesting panel discussion, and can I hand over to you, Professor Evans, to moderate. Thank you.
Thank you, Justice Bromberg, and thank you everyone for joining us tonight and for the very large number of questions we've already got. We will not be able to get through them all, but looking forward to a great discussion with Heiner and Lucy, and invite them to turn their cameras on now so that we can get started. Heiner, I might start with you. Metaphor can sometimes be important here because it does shape the way we think, and we often talk about balancing human rights when there's more than one right at play, as there is in this case. This seminar is about maximising rights. Do you want to talk us a little bit through which frameworks you think work best when we're having these sorts of discussions?
Yeah, thank you very much for this question. Balancing is a very popular term, and it indicates a nuanced approach. That's why we all like to be called balanced person, and we like also to engage in balancing. But there are also some pitfalls with that metaphor, especially when it comes to understanding the relationship between different rights, because balancing somehow invokes the metaphor of the scales, the weighing scales. And it seems to suggest a zero-sum logic. So when one scale goes up, the other goes down, and vice versa. So in order to get the most of one right, it looks like we have to sacrifice the other right to a certain degree, or we have to strike some form of compromise. And the compromise could be a wishy-washy, 50-50, a little bit of everything. And that's why I prefer maximizing. I mean, it's not naive to talk about maximizing, at least as an aspiration. So somehow overcome the idea that in order, for instance, to promote gender issues, you have to sacrifice freedom of religion or belief, or the other way around. Let's always try to go for synergies, knowing that it's not always working. We are not in an ideal world, but nonetheless, I would actually stick to that aspiration. So in that sense, balancing, okay, is fair enough. We will certainly not be able to prevent that in total, but the first step would be for me to really try to maximize, to find a way of coordinating different rights issues so that we can benefit from all these human rights to the maximum degree possible. Yeah, and that of course includes freedom of religion or belief. Let me say, I mean, as a former rapporteur, my heart goes very much for that right. Freedom of religion or belief. I would actually go so far as to say, without freedom of religion or belief, the human rights approach would be incomplete. It would cease to be fully humane. Yeah, it's important, but we have to understand freedom of religion or belief also within the broader context of the human rights approach when trying to make sense of it.
Well, let's have a look at that broader human rights approach, because there are many rights at stake when we're thinking about religious schools and non-discrimination. Of course, religious freedom, both individual and collective, non-discrimination rights, but also rights to education, rights to employment, and rights of children, rights of parents. Lucy, turning to you, the two that are going to come up most commonly here are non-discrimination and religious freedom. And we have quite a few questions that are coming in that are asking, you know, what's the hierarchy? Which one's more important if they clash? And so perhaps could you just talk us through how you think we should think about this intersection between religious freedom and freedom of discrimination in this context?
Well, I think one thing to remember is that non-discrimination covers religious discrimination as well as discrimination on other grounds. So in that sense, religion comes in both sides of the scale to the extent that you're saying that there's balancing. And I think that's important. So religious freedom and religious discrimination are connected, but they're not the same thing. Religious freedom and non-discrimination at the same time are separate rights. And the non-discrimination, of course, includes non-discrimination on other grounds. So that arises quite regularly, that these things are, if you like, in conflict. And the way that the legal framework deals with that within the discrimination framework is to have most of the discrimination rights founded on the idea of proportionality. So where you have an indirect discrimination, for example, discrimination on grounds of religion actually having an impact on sex discrimination, you have to be able to show that any restriction on either of those rights is proportionate. And that involves having a sense that there's a legitimate reason for the rule that is causing the discrimination, and that any limitation is justified as proportionate, it's really necessary. And that enables that a court or any other organisation trying to reconcile these rights to have some pointers as to what to look for. What's the purpose of the rule, and how necessary is it for either side in order to enable them to function, and then some sort of a weighing, as Professor Bradfeld's saying, to enable you to come to some sort of an accord to enable you to balance those things. So the question is about trying to have some sense of proportionality as you, as Professor Bradfeld said, trying to maximise both sides is a good aim.
And perhaps, Lucy, just continuing with you for a moment, taking those sort of general principles and applying them in the context of religious schools and the relationship with students, but also particularly the relationship with staff, and you know, the obvious case of a religious school that might have a religious teaching that, let's say that people who are heterosexual couples who are engaging in non-marital relationships provide a bad example. And therefore shouldn't be employed in the school, but there are plenty of other examples. What might we learn from other countries and the way some of these issues are handled in a more sort of concrete sense?
So one of the other aspects I mentioned about the proportionality within the discrimination framework is, of course, that the religious freedom is also also has concepts of proportionality within it too. So the right to religious freedom is not an absolute right. The right to believe what you believe is absolute, but the right to practice that, whilst it's protected, you have a right to practice your religion in conjunction with others. So you do have a group right as well as an individual right. That right isn't absolute. It's subject to being held in balance with the rights of others. And so both the discrimination framework and the rights framework are both qualified rights and involve some element of taking into account the rights of others. And so the right to religious freedom may involve the right to believe what you believe, but it's not an absolute right to run a school according to every element of the teaching, for example. That's the framework through which international human rights law would come in and engage in the balancing. So there isn't an unqualified right to run the school according to every element of the teaching. But there is a right in the European context, for example, which of course covers a huge range of context, religious context. I'm actually speaking from Ireland, which has deeply embedded religious rules within its legal framework. And that's different then from France, which will be different from Greece. So huge varieties. And the way in which the legal framework engages with that is to have an overarching rule that says that does allow some exceptions for religious ethos organisations in terms of discrimination law, to allow religious ethos organisations to employ those who share the religion and to engage and to have that religious ethos practiced and protected. So a religious school would be able to do a lot in relation to religious freedom. They would be able to celebrate religious holidays, they'd be able to teach the religious faith in school, enjoy teaching about nature and God and loving relationships and so on. So there's a lot of religious freedom that is allowed within the school context, but it is subject to the non-discrimination rules that apply, that allow, that provide protection on grounds of sex and sexual orientation. And those rules are not limited. They're not restricted because of the religious organisation. They may be part of a context if one's assessing indirect discrimination, but they don't provide a defence, if you like, or an exemption to religious organisations, and that applies across the European framework. And as I say, across a wide range of cultural practices within the European Union.
And Heiner, another set of interests that are at play, or rights that are at play here, you have the parental right to choose the religious education of their child, which is protected in international law. The child at some point in time has their own independent religious freedom rights, which may sometimes align very strongly with the parents, but at some point might diverge. But there's also a right to education. So how might we think about that cluster of rights in terms of maximising it? What sort of examples might we think of where that can be done well?
Okay, Convention on the Rights of the Child also talks about freedom of religion or belief. It's Article 14, and it accords the status of a right holder. So the child is a right holder, but then parents at the same time also have duties and rights in that context, and they have the right to also provide their direction to the child. So other than the state, which is supposed to be neutral with regard to different religions, the family background does not imply such a claim or such an aspiration of neutrality. So parents have the right to give direction to the child with regard to the child's right to freedom of religion, and that should be done in a context also of respecting the evolving capacities of the child. So it's rather complex. But you see that also reflected in other provisions. Article 18 of the International Covenant on Civil and Political Rights, which is the most important freedom of religion guarantee in international law. It also has a paragraph dealing with parental claims. So parents should be respected in their liberty also to provide an upbringing of the child in accordance with the moral and religious understanding, convictions of the family. So there you see, I mean, we have children's rights, we have parental rights, and actually my reading of the Children's Rights Convention is it strengthens family relations. So it's not isolating the child, taking the child out of that context, but rather strengthening also parental rights and duties from a specific angle. And of course, that does not deny the possibility of conflicts, and in some cases also the need for the state to interfere. Yeah, sometimes the state has to interfere also to protect the right of the child. For instance, the right to education against parents. I mean, we do have, of course, experiences that some parents may think education is not so important for girls. I mean, that is a reality in many parts of the world. And that's why parental rights have a strong protection, but not an absolute protection. And state interference is not something we should really appreciate, but we have to acknowledge, of course, situations where there is a need for state intervention. So the state is actually in charge of guaranteeing all the rights for all, but that includes the right to education. That's indispensable. So here we have to make sure that while promoting parental rights to freedom of religion or belief and other rights, the right of education is always also protected. That's very clear. If I may make a little comment to what Lucy said before, we fully agree on everything. Lucy, you said, and you rightly said, freedom of religion or belief in its external dimensions is not absolute. True, it's not absolute, but still it's strong. It's a strong right, and we should always insist that the burden of justification for limitation falls on the side of the state. Yeah, so we should start on the assumption people have a right to enjoy their freedom of religion or belief, and if limitations are deemed necessary, then the burden of justification falls on the side of those who argue for limitations. So in order to keep the structure very clear, rule and exception. So no one should be in a situation where they have to justify their insistence on the right. Yeah, it's always limitations need justification. I'm sure we fully agree on that. So it's just in order to complement what you said. Yeah, but we are in full agreement.
Thanks, Heiner. And of course, Article 18 and thinking about parents' rights developed very much in line with the times when the example of the Nazi and fascist regimes and the extent to which the state tried to take over the entire ideological and cultural basis of education and separate children from their parents in that way, and a growing concern about communist regimes doing much the same thing. So the focus was very much on the overpowerful state and perhaps not as thoughtful as it might have been about sometimes some of the issues around parents and the intersection with children and their rights. Let's take some of the things you've talked about, and Lucy, I'll turn to you now and think about the rights of individuals, and particularly probably in relation to non-discrimination. but also institutional autonomy, and the extent to which we should understand institutional autonomy as an important part of religious freedom, its collective dimension. Perhaps, do you have some ideas about, and again, particularly in this context of religious schools?
So I think it's important the religious autonomy of the organisation is respected within the legal framework, certainly in the European legal framework, that there are additional there's one of the contextual factors that's taken into account when assessing whether or not it's proportionate to have a limitation is the religious ethos of the organisation. So religious groups as well as religious individuals have rights to that extent, or at least they're recognised. But in terms of the underpinning of that right, in my mind, the collective right is still founded on the collective individual right. It's derived from the individuals whose freedom we're protecting. So the human rights framework protects the right of the individual to religious freedom together with others, but it's still its underpinning, I think, is individual. And so I think whilst it's correct and the legal process does protect the rights of the group, the religious institution, we need to remember that that is founded and derived from the individuals, and not, as it were, double count the rights not only of the religious groups, but also if we're using that weighing scale, that you don't get double counting because you have the group and the individual, and then you can never, if you like, the others can never have their rights perhaps respected. So, but the legal framework does have an element of respect for the organisations which are organised according to a religious ethos. And the idea is that the religious ethos and the need to maintain the religious ethos is taken into account when assessing whether or not a limitation is proportionate. But that does involve a proper assessment of the religious ethos of the organisation. So there's a case from that arose in Germany involving a religious hospital that wanted to that dismissed a member of the medical staff. It was a Catholic hospital, and he had remarried outside of the teaching of the Catholic Church, and the hospital said, well, that's in breach of our religious ethos, and so they had dismissed him, and that was said to be unlawful, partly because they hadn't assessed correctly the proportionality of the German law didn't require them to look at the proportionality of that decision. They just were allowed to say, well, if you don't comply with our rules, you go. And so what the European court said was you have to have a proportionality element in that assessment. And in assessing proportionality in a case like that, you have to look at the organisation and consider, for example, the size of the organisation and how much religion was really embedded within it. And also, in this case, a lot of other doctors weren't Catholic and therefore wouldn't have been dismissed if they'd got divorced without complying with the rules. And so they were really saying that some of these marriage rules were not embedded in the ethos of running a hospital. So looking at, and it would have been utterly different if the person was wanting to be a priest or a clergy or something and complying with the rules of the organisation. So there's a sort of an assessment in terms of the proportionality of the ethos of the organisation, but certainly it gets a seat at the table, if you like, the collective rights and the ethos of the organisation. When we're looking at that, if we're using the metaphor of balancing, the right is in there, but it's not absolute.
Thanks, Susie. And Heine, we might tease this out a little bit more, because I know you have some views on some of this area too, that when we're thinking about when it might be appropriate to limit rights, sometimes people talk about faith-based communities or institutional autonomy, and that can cover a very wide variety of things, from the local Catholic Church employee and the employment of a priest through to some local shop that might be run by a Catholic couple to try and raise money for the church. We're talking about schools here. So do you want to just talk a little bit about how we should think about different types of faith communities?
Yes, I mean, definitely we need specification. But before going into that, let me also emphasize the community dimension of freedom of religion and belief. I fully agree with what Lucy said. The angle is the dignity and the rights of the individual. I mean, if you start with the Universal Declaration, The first word is recognition of the inherent dignity. And then it comes of all members of the human family. There's a relational component. So we have to protect rights of individuals, but typically these rights imply the possibility of joining together with others, a freedom of assembly, freedom of association, also freedom of democratic discourse. I mean, always we have that community dimension, and also the institutional dimension, freedom of expression, for instance, was traditionally always presented as freedom of the press. Yeah, that's a, let's say, almost romantic notion for us today. And here, I mean, freedom of religion fully fits into that matrix. So the angle is, of course, individuals, but individuals wish to come together with others. Often they worship together with others, or they need institutions. Charity organizations, of course, churches, mosques, and other organizations. The institutional component is of huge importance, but still we have to define them from the understanding of its individuals attributing that significance to the institution. So we don't have a, let's say, blanket recognition of religious institutions and its status quo. And here I think differentiation really has to play a role, and I would simply highlight what Lucy already said in maybe my words. Of course, it does make a difference whether you focus on the right of a church to elect their own clergy according to their own rules, and that's very important for many religious communities. I mean, the history of religion is full of examples where this question has led to splits, to schisms. Yeah, so the ability to understand, I mean, who are we, who is going to represent our community, our church or mosque or whatever the community may be. So here, I mean, that is a very strong claim under freedom of religion and belief. Then when it comes to other organizations, so maybe a school run by a church, but taking over educational tasks, which also fall under the ambit of state supervision, the state being the guarantor of freedom of religion and belief, the situation is somewhat different. I mean, still freedom of religion applies, but it applies in a different way. And then it comes, I mean, for instance, you have to differentiate between whether a teacher is teaching religious instruction in school. And of course, there you can have much more far-reaching expectations on that teacher from the side of the religious community, in comparison, for instance, if it's a person responsible for running the computer system of that school, yeah, which still may be a Catholic school, but here it would be much less plausible to stipulate religious ethos questions and also marriage questions, divorce issues from the Catholic perspective on a person running the computer system in a Catholic school. And the jurisdiction actually has spelled that out, and Lucy already gave some examples. Also, the European Code of Human Rights, for instance, differentiate between an organist working in a church but not being visible as an organist somehow in backstage, and a person responsible for the media work, spokesperson of a religious community. And of course, here freedom of religion always applies, but it applies in a differentiated way. And that's, I think, we have to understand that in order really to make sense of freedom of religion and belief. Yeah, a blanket right for institutions who just use the label religion would not be sustainable. It would actually undermine freedom of religion and belief.
But in my experience of all the institutions that various religions run outside the core church, mosque, temple, and so forth, schools tend to be the one that the most controversial, and because the formation of young people, the value set of young people, keeping young people inside the faith is the key issue as to whether the faith is going to be transmitted from one generation to the next and whether it will survive. And so when it comes to issues of employment, I would often hear, in counter to what you have just said, Heine, people saying, yes, of course, the school principal or the religious education teacher, yes, that's particularly important. But if we are serious about our values, we would want everybody in the school community to reflect those, because the gardener could be a role model, the person who does the computer system, if we look there. So I suppose the last question before we go to the Q&A from the public, just a bit of a sense about how discrimination laws in different countries allow for religious institutions to discriminate on the basis of employment. You know, there's some principles, Lucy, particularly from the European Court in Europe. You've touched on some of them already.
Yeah.
But how much does that, at least European law, allow for that type of thinking?
So the European law does allow for, as I've said, the religious ethos to be taken into account in allowing, which would allow religious organisations to have preferential hiring effectively for people who share the religious ethos in order to maintain the religious ethos. That's clear. That's one legal framework. So the religious discrimination, as it were, has a special occupational requirement exception that is broader than the standard one, because it allows you to take into account the ethos, and it accepts the need for the organisation to wish to maintain the religious ethos. So that's covering exactly what you're saying, allows you to say we would like everybody in our organisation to share the religious ethos. But the but is that there's a separate legal framework, which is or a separate heading, which is sex discrimination and sexual orientation discrimination law, and that doesn't have a religious ethos exception. So the European law says you can discriminate in favour, if you like, of those who share your religion to create a religious ethos, but it does say that you are not allowed to discriminate on other grounds. So then you have to turn to sex discrimination law and sexual orientation discrimination law. That says that you can't discriminate in employment on grounds of sex or sexual orientation. But that also carries with it an exception where there's a genuine occupational requirement to be of that particular sex. But that once you're in the context of sex discrimination and sexual orientation discrimination, is very strict. And so certainly within the UK context, for example, it would allow you to say you have to be male if you're going to be a priest, and that you have to be straight to be a priest. That complies with the teaching of the church. But that's a very narrow exception, because that's just the individuals who are performing religious rites, if you like. Once you get outside of that into teaching or nursing, I think that certainly within the UK context, it's very clear that those exceptions that allow sex discrimination or sexual orientation discrimination don't apply outside of the very protection of the sort of core religious right, which is if you believe that you have to be male to be a priest to carry out the sacrament of marriage or communion or the mass, clearly that would be a big infringement of the religious freedom, because it's so core to the expression of the religion. But the further you move away from that, the more the rules are restricted. So in the UK, for example, you can require that in a faith-based school that you have the leadership have to share the faith, but that doesn't allow you to discriminate on grounds of sex or sexual orientation. It's a separate set of rules, if you like, that are implemented there. Sorry, just one final thing. Of course, saying that you have to share the faith might involve indirect discrimination, because you might say, actually, if you share our faith, you won't be accepting of gay relationships. And so then you're into indirect discrimination, which has to be justified. And your explanation would then have to be that it's justified and proportionate. And I think it would be quite difficult to do that. The courts are pretty strict on justifying indirect sex or sexual orientation discrimination.
Thank you.
So not a clear-cut answer, but as always with legal questions, the answer is always it depends. But we know, I think what we're discussing is which are the issues that come into the it depends discussion, and the right to non-discrimination on grounds of sex and sexual orientation is right in there with as a right that is going to have to be discussed along with the religious freedom rights.
We'll turn to the questions that people have been sending in. There are a very large number of questions, a lot of interest. Thank you very much. We only have 10 minutes left, so we will not be able to get to them all, but as Justice Bromberg said, they will be considered by the ALRC, so please do feel free to keep sending questions in. And Heine, we've had a number of questions, and in some ways I'm inviting you to pick up where Lucy left off here, particularly about LGBTQI communities in schools, both staff and students, but institutions whose faith may not see itself as compatible with celebrating or even being accepting of LGBTQI individuals. How do you think we should go about thinking about that? And in your time as rapporteur, you might have seen examples from various parts of the world that you could refer to.
Sorry, I did not fully understand your question.
Sorry, just really, how should religious schools be thinking if their religion is condemning of, for example, homosexuality? How might they be thinking about dealing with staff and students?
Yeah. Okay. I mean, when answering this question, one of course has always to also include the state. Because I mean, of course, we can also talk about what I would like religious schools to do, how they should, but that would be a sort of moral postulate. But school issues, for good reasons, fall within the ambit of state supervision, because only by accepting the role of the state, which is of course not an absolute role, yeah, it's also conditioned by other rights structures, but with only when appreciating that role of the state can we turn education also into a human rights issue. Human rights are enforceable, yeah. So in order to make sure that all children, boys and girls, and maybe children of a third gender, fully benefit from school education, the state has to take a role, and that's why it cannot be just left to the decision of the school board, for instance, the school institution. The role of the state is a complex one, because the state is in charge of guaranteeing all human rights, including also freedom of religion and belief. So trying to also enforce the right to education for children in a way that fully respects also parental rights, yeah, but not sacrificing the right to education. And that is, of course, a very complicated task. I think in order to be able to answer that question, we have to appreciate the role of the state as a conditioned role, but nonetheless as an indispensable factor. And so also religious schools somehow move within the national curriculum. And that's something we have to understand and also to accept and to make sense of.
And there have been a number of questions about that, whether normal educational standards apply. And that is the case in most countries, that being a religious school doesn't exclude you from having to teach maths appropriately or ensuring that the normal educational standards apply. We have a couple of questions here, and I might roll them a little bit together. Australia has a large amount of public funding for religious schools. So religious schools in Australia are private schools, and parents pay sometimes a small amount of money, sometimes a large amount of money. But the state also pays quite a substantial amount of money. Over $18 billion of taxpayers' money goes into religious schools in Australia every year. Lucy, does that change anything? And how common is that? Lots of countries have taxpayers' money into schools?
It's complicated because there's lots of different formulas, I think, but a lot of countries have state funding of religious schools. So certainly in the UK, it's very complicated, but there are schools with a religious foundation that are pretty much funded by the state, and they're called state schools, so they're not called private schools because the state funds them, but the religious organisation, for example, owns the buildings and engages in the governance of the schools. I think many other countries, France is famously a secular state and there's no state funding for their schools, but actually they do fund significant amounts of money towards any school that teaches a national curriculum. So in my British viewpoint, that looks to me rather astonishingly like state funding for religious schools, but the official line for the French state is that it's not. But so you have all sorts. Greece has a lot of religious engagement. I know you'll be able to tell us about the German situation, but there's a lot of interaction between state funding and schools, certainly. But so I think it makes a difference. It gives us, but as Heine said, if the state already has a role in education, whether it's private or funded or state funded, but I guess if it's state funded, it gives you more of a reason for intervention. But I think that we have to remember the non-discrimination rights in relation to sex and sexual orientation, and say that, I mean, Heine's example of education of girls, I don't think many people would be quite happy to sit by and say, oh, well, we'll allow, we won't worry about this because it's not state funded if there's discrimination in relation to the funding of girls' education. If we discovered that maths was being taught differently, the girls don't need to worry about calculus, it's a little bit too difficult. We wouldn't just say, oh, well, that's fine, it's state, it's not state funded. So I think when we remember the fundamental rights that we're holding together here, it is, I think we can see that the state funding is relevant, but it's not it's not the overriding interest here, and it's not the overriding reason for action where action is needed to maximise the rights of everybody here.
Yeah, if I may briefly confirm, the situation in Germany is roughly comparable. So religious schools do receive a lot of state funding, but they are bound by the principles of the national curriculum anyway. So even as religious schools rejecting state funding would not have an exit option. Yeah, so yeah, but as the state funding is, I would say, rather it's a rule rather than an exception, at least across Europe.
And we have only 1 or 2 minutes to go. So picking up on that word exit, I'll ask one final question, and each of you might want to just say a couple of sentences about, there's an argument that's being put here, if individuals don't like the rules of religious schools, surely they can just leave those. There are plenty of public schools, which is true in Australia, where there is no religion taught. So shouldn't we just leave religious schools to be able to fully pursue their own ethos and say it's fine, yeah, girls can be taught elsewhere? So Heine, you have a strong reaction to that. Is exit enough to protect everybody's rights?
No, I mean, because I mean the right to education is simply indispensable, and and that's why also you cannot escape the supervisory function, whatever that implies. I mean, we can discuss how far it should go. We can maybe also reform it internally, but you cannot escape the supervisory function of the state concerning education without sacrificing education as a human right, because that's the purpose of human rights. They should be guaranteed. Yeah, and that's why, I mean, this idea is too simple. It would really fail to do justice to the status of education as a human right.
And can I just come in as well in terms of whose right of exit, I think is really important as well. So the child in the school who will have their own, may not have a right of exit if their sexual orientation doesn't meet with the rules of the faith in which they're being brought up, but they may not. They have the right. That rights of the child, I think, is also really important in terms of that question about exit. Whose right of exit? The parents or the child or the family? So I think we have to bear in mind very carefully that there are quite a few individuals in any of these cases, the parents, the child, the religious organisation, and they all have rights, and they may not, the rights of exit of each of them are not equal in that. So I think that's a significant issue as well.
Well, Lucy and Heine, thank you. It's been a fascinating discussion, and I think we could have spoken for hours and still had a huge amount to tease out, but thank you for your time quite early this morning, I know, for both of you. And a pleasure to hand over now to Justice Rothman for some concluding remarks.
Thank you very much. Like we learn in most litigation, no expert opinion is ever clear-cut. The difficulty in this area is, as has been pointed out, the issue of balancing what may otherwise be intersecting rights. and I like the expression used by Professor Bielefeld of maximising rights, which I think is an important aspect of the issues. It has to be said that, notwithstanding that the ALRC inquiry has been tasked with the idea of examining international obligations of the Australian government and factoring those aspects into the inquiry, there are some unique features of the Australian education system which do not easily lend themselves to overseas comparisons. All schools in Australia must be registered, and to be registered they have to comply with the curriculum arrangements that the government, state usually, imposes. That's true whether they receive funding or they don't receive funding. And to conduct a school that is not registered is in fact a criminal offence, I think in all states, but certainly in most states. So the issue of curriculum and autonomy in curriculum is not an issue certainly with which the ALRC is going to deal. The policies that have been laid down and the 3 dot points that have been the subject of remittal to the ALRC inquiry encapsulate the intersecting rights that otherwise exist and deal with what are, in small areas and usually handled very well by schools, areas that sometimes conflict. On the one hand, you have the genuine religious need to promulgate the religion and or to build a community of faith, particularly in minority religions or in smaller community schools. And on the other hand, you have the important principle of equal justice, which is and has been described by the High Court as a fundamental norm of democracy and certainly in the exercise of judicial power, but also in the exercise of legislative power. People are entitled to the dignity of a human being, and that is all people, and they are entitled to be treated equally, which means that where there is no relevant difference between people, they are entitled to equal rights, and where there are relevant differences, they are entitled to be treated differently, the difference rationally and reasonably reflecting the differences, but the relevant differences between them. That is a fundamental which is embodied in our Anti-Discrimination Acts generally, and which lies at the core of many of the international obligations about which these experts have been speaking. I would like to thank Professor Bielefeld for his extraordinarily good insight into the intersection, and his experience speaks for itself, and it has been most helpful to me. I thank Professor Vickers also for her similarly expert opinions. I'd also like to thank Professor Vickers because she has made herself available to the advisory committee to the ALRC inquiry and has been most useful in looking at some of the English issues and indeed the decisions that have been made. I'd also like to thank very much Professor Evans for conducting the Q&A and the panel discussion with such aplomb. No wonder she's the Vice Chancellor of Griffith University. I'd like to thank all of them. I think the important issue, or one of the important issues, as I said earlier, was in terms of balancing rights, to maximise the rights to the extent they can be, and where rights are interfered with, to require justification of that interference. And a justification on the basis of proportionality is a justification which has found its way into many, if not all, of the anti-discrimination statutes on the books. We have in Australia, of course, state statutes about anti-discrimination and Commonwealth statutes. The ALRC inquiry is looking only at the Commonwealth statutes, but there is a need for uniformity. Otherwise, different standards will apply between different states, and the strictest standards will apply, or stricter standards will apply, as between Commonwealth and state issues. I also have taken cognizance of the notion that children are right holders and parents have duties and obligations to children, as does the state. The issue of the total autonomy of religious institutions, and I include in that certainly religious education institutions, is necessarily qualified. I've mentioned to most of the consultees with whom we have met that if there were still religions that believed in human sacrifice, the state would necessarily interfere. During the course of the apartheid regime in South Africa, there were some portions of some religions that taught that evolution applied to blacks and whites were created by God. That too, without any question, would be something that was prohibited by Australia, and certainly is now prohibited by South Africa. So one really starts from the premise that both Professor Vickers and Professor Bilfield dealt with, which is the dignity of the human being, all human beings, as members of society, and their right to be treated equally, that those who believe in a religion have a right to believe in that religion and to promulgate it, and those who do not have a right not to believe in that religion. The issue becomes whether in genuinely seeking to promulgate their religion, the religious education institutions and religious institutions generally can proportionately deal with some of the areas of anti-discrimination, and that is one of the factors, if not the most central factor, with which the ALRC inquiry is dealing. Lastly, I'd like to thank very much Walters Kluwer. Jenny, who organised all of these events, has been quite superb, and her facilities have been excellent, and it's necessary for me to hand over to her. I'd like to thank everybody. I'd certainly like to thank all the participants in the webinar, and in particular ask them to stay in touch and reiterate what has already been said, that if there are questions that have not been answered or points that wish to be made, you are more than welcome to bring them to the attention of the ALRC, and we will certainly consider them, as we have all of the submissions that have been made and all of the points made in consultations that we have had over the last 8 months, if not longer. Other than that, I think it's necessary simply for me to thank everybody for participating. Thank you for your comments and questions, and hand it over to Jenny Sinprasuth, sorry.
Thank you, Judge. I'll just take a couple of minutes to wrap up on behalf of Walters Kluwer. So if you aren't across who Walters Kluwer is, we're a global company, and we're one of the world's largest providers of tax, accounting, HR, and legal information software and services. We've been around for around 180 years, and we're really proud to work with the Australian Law Reform Commission to bring you topics such as these each year. Just briefly touch on, I guess, where we do cross over is in the realm of the legal area. So we do have a solution called CCH Pinpoint, which is written and curated by in-house legal practitioners and experts who've come from industry and have now moved to working on content So we have that over 33 practice areas, including discrimination law. And it is a very trusted resource, and we've been doing this for a very, very long time. So if you are interested in learning more or actually experiencing our online legal research platform, please let us know in the exit survey. And obviously you can reach out as well at any point in time. So thanks again, everyone, for joining us. Thank you again to all our presenters and speakers for a really insightful and robust discussion today. I'd like to thank you and wrap up and let you enjoy the rest of your evening. Thank you.